In Roanoke, Virginia, a man who was sentenced to nearly 4 decades in prison for his alleged role in a murder just got his conviction tossed out. Because the court realized that suspicion, coincidence, and borrowing your wife's car aren't actually crimes. Who knew? This legal plot twist stars Alsharrief Malik Mahoney, who prosecutors were convinced was part of a murder conspiracy. Why? Not because he pulled the trigger, not because he planned the hit, and not because anyone saw him at the crime scene during the actual shooting. No, Mahoney's mistake was being nearby and in possession of a Chevy Lumina. Let's rewind. Back in May of 2023, Mahoney's cousin, Jaleel Tate, was shot and killed while sitting in his car at the Panorama Apartments. The shooter? A black man in a white shirt seen fleeing the scene alone in a white Chevrolet Lumina. The car was never found. The shooter? Never identified. Oh. But here's where it gets interesting. Mahoney's wife owns a white Lumina. Mahoney drove that car earlier in the day. And later that night, after the shooting, he was seen getting into the passenger seat of that same car as it drove off. From that point forward, the prosecution apparently decided that's our guy. Never mind that the driver, the shooter, is still a mystery. Never mind that Mahoney wasn't on camera during the shooting. Never mind that there's zero evidence he knew a shooting was about to happen. The Commonwealth built its case on a suspicious coincidence, a shared vehicle, and a cousin who reportedly said my brother did it while bleeding to death, but may have been referring to someone else entirely because another guy at the scene also went by the nickname Shah. So to recap, 2 people called Shah, one anonymous gunman, and a white Lumina with more drama than horsepower. Still, Mahoney was convicted of second-degree murder as a principal in the second degree, plus firearm charges and shooting at an occupied vehicle, despite not actually shooting anything. He was sentenced to 38 years in prison, with 13 suspended. Prosecutors said he helped make the murder happen by possibly letting the shooter use the Lumina. But this week, the Virginia Court of Appeals came through like the adult in the room, calmly pointing out that borrowing a car and showing up later isn't the same as planning a murder. The court said there was no evidence that Mahoney shared the shooter's criminal intent. No proof that he knew anyone would be shot, or why, or by whom. Just some sketchy circumstantial stuff and a heavy dose of prosecutorial imagination. They even brought up a 1997 case, Littlejohn, where a woman let a killer hop in her car after a mass shooting, and even that wasn't enough to prove she was in on it. So if that didn't count, neither did Mahoney's post-shooting ride-along. And about that Lumina? Sure, it was at the scene. But as the court noted, simply being in the area, not calling 911 or later changing your phone number doesn't add up to aiding and abetting murder. It adds up to bad decisions, maybe, but not guilt beyond a reasonable doubt. In the end, the appeals court reversed Mahoney's convictions and vacated the judgment entirely. No retrial, case closed. Mahoney is a free man. Not because he's a hero, but because, legally speaking, being awkward and nearby isn't a felony, at least not yet. So, what's the takeaway here? If you're going to build a murder case, maybe find the actual murderer. Maybe have a witness who saw something. Maybe try a motive. And maybe, just maybe, don't base your entire prosecution on, well, he could have known something. Because if Virginia courts keep this up, we're going to need a lot more white Chevys. And a whole lot more reasonable doubt. To stay up to date on the latest crime and justice news, subscribe to Breaking Through News on YouTube or at breakingthrough.com.